Well, welcome everybody. Those of you in person here today and online. My name is Harvey Ryder, and I'm co-chair of our Brown Bag Lunch program. One of our other co-chairs, Richard Fulton, is off camera, sitting right across from me. This is an ongoing program sponsored by the American Jewish Committee, the Tzedek DC, the Jewish Community Relations Council of Greater Washington, and the American Association of Jewish Lawyers and Jurists, and the Jewish Federation of Greater Washington. So I want to thank everybody for being here today. I'm going to ask you all to stay on mute. At the end, if we can, Vicki, maybe we'll ask people to put their questions in the chat box, and if someone wants to follow up, we can take them off of mute so that they can pose their questions directly to Art. So I don't want to waste a lot more time and get right to it. Art Spitzer is here for, I don't know, probably the 15th, 16th time to give a recap of the most recent Supreme Court term and the civil rights, civil liberties decisions handed down by the Supreme Court. And there were, of course, a number of major ones this past term. And maybe Art will give a preview of some of the ones that might come up in the next term. So we should have time for questions. And I want to thank Art. His bio, really impressive one, is already online. So I'm going to save time by just saying welcome back, Art.
Thank you, Harvey. I will try to talk fast so that we have some time for questions and answers at the end. I should begin by saying that I'm not speaking for the ACLU. I have my own opinions about some of these cases. They don't always coincide. In at least one case, they definitely don't coincide with the ACLU, so you should understand that I'm speaking personally. And as usual, I try to start with cases that have a religious angle, given the nature of the audience. Last year, there were several important cases involving religious issues. This year, there's really only one, and it turns out to be a non-controversial case, and that was Groff against Postmaster General DeJoy. Ever since TWA against Hardison in 1977, everyone has understood that when a person seeks a religious accommodation at his or her workplace, you need to leave early on a Friday afternoon, you need to take off for Rosh Hashanah, you don't work on Shabbat or Sabbath if you're speaking a different language, that an employer, even though Title VII of the 1964 Civil Rights Act prohibits discrimination based on religion, an employer doesn't have to accommodate those requests if it would cost more than a de minimis, if it would impose more than a de minimis burden on the employer. De minimis means trivial, not worth thinking about. More than de minimis means just a tiny bit more than that. And so everyone has understood for decades that employers really have very little obligation to accommodate religious needs at the workplace. Maybe they have to set up a voluntary exchange system if you can find a volunteer to take the shift that you can't take, but they don't really have to go much beyond that. The words of the Civil Rights Act itself are undue hardship, that an employer should grant such an accommodation unless it would cause an undue hardship. How undue hardship got transmogrified into a tiny bit more than de minimis is not clear, except that back in the 1970s, people were really quite concerned that if the government was compelling private employers to grant these kinds of religious accommodations, they'd be violating the Establishment Clause. People who had religious needs would be getting an extra bonus, and the government would be ordering that they get an extra bonus, while people who didn't have religious needs would be turned into second-class citizens. And at the, when the Establishment Clause jurisprudence was at its height, that was a real concern, and that's probably the reason why that standard got adopted. Well, the Establishment Clause jurisprudence has now taken a nosedive, as some of the cases from last year showed. And now the court, by a unanimous decision, said that undue hardship means undue hardship. And what is undue depends on the facts of the particular situation. It may depend on the size of the business. It may depend on who the other employees are. Does so many people need to take off for Rosh Hashanah that the company couldn't operate if it granted these accommodations to everybody? Or is it something the company could easily handle? So there's going to be now years of follow-up litigation about just what undue hardship means in a given context. So it's good for the lawyers, but it's also good for people with religious obligations, because employers now will be much more hesitant not to grant an accommodation, knowing that that could result in litigation that they could lose. It'll put it more on a par, I would say, with the Americans with Disabilities Act, where employers recognize that they have to take accommodation requests seriously. Doesn't mean they always have to say yes. It certainly allows them to propose an alternative that would serve the individual's needs with less burden on the employer. But all of that is now open for business. I should just mention, given the audience, that, by the way, Harvey and I worked together maybe 30 years ago on an amendment to the DC Human Rights Act that tried to push this accommodation obligation as far as we could, given what the Supreme Court had said. And so there's a section in the DC Code that depending on the size of the company, depending on the size of the company, puts the burden on the employer to establish undue hardship, and suggests a number of ways in which accommodation can be made, shifting with other employees, letting the employee take unpaid time off was sort of the last in a list of potential accommodations. It does include the sentence that says an accommodation would cause an employer undue hardship when it would cause the employer to incur more than de minimis costs, coming right out of the Supreme Court. And I think the next task for the DC Counsel, which maybe Harvey and I will get to work on again, will be just to take that sentence out. And I think the rest of that section remains quite useful. There was also one case that you might call religion adjacent. It was really a First Amendment free speech case as the court viewed it, but there was religion in the background, and that's 303 Creative against Elenis. This is the wedding website case. Lori Smith runs a one-person website design business, and she's in Colorado. She wanted to expand her business to include designing wedding websites for people, but she was concerned, with good reason, that, and she's a devout Christian. She does not make websites that she feels are in violation of her beliefs, and that would include things that encourage violence, things that demean other people, things that promote atheism. She had a list of things she wouldn't do in her ongoing website design business, but she also wouldn't design a website for a same-sex marriage because she thinks that's against God's will. She feared, with good reason, that the Colorado Civil Rights Commission would bring an enforcement action against her if she proceeded to expand her business but refused to accept business involving same-sex weddings. And so she proactively filed a lawsuit seeking a declaration and an injunction that she could go ahead and make wedding websites without having to do same-sex wedding websites. There's been a lot of stuff on social media in the last couple of weeks about how this case was not really a case, that the Supreme Court sort of made it up out of whole cloth. How could they do this when no one had ever asked her? And I'd like to take this opportunity to debunk that. It's called this case comes in a category that's called a pre-enforcement challenge. That's got a name suggesting that it's a real thing, and it is a real thing. The ACLU and other organizations file pre-enforcement challenges frequently. There has to be a credible fear of prosecution or enforcement, and here there certainly was. But if you think back, you'll remember many cases where some governor signs a law establishing new restrictions on abortion, and bam, the ACLU and Planned Parenthood are in court that afternoon or the next morning before there's been any enforcement, before any woman has actually tried to get an abortion in violation of that law. And there's nothing wrong with those cases. The courts consider them all the time. And the theory is, and it's an especially strong theory in the First Amendment area, the theory is a person shouldn't have to wait to get arrested or sued by the government before speaking. You should be able to know in advance if there's a law that would unconstitutionally restrict your speech, you should be able to get a court to tell you in advance that it's unconstitutional. And we, as I said, we take advantage of that a lot. So there was nothing wrong with this case in that way. And in fact, Colorado stipulated means agreed in a formal binding way in the lawsuit to a variety of facts that helped Ms. Smith a great deal in the case. And if I had the opportunity to ask the Colorado Attorney General why he did that, I would. But they agreed that Ms. Smith is willing to work with all people, regardless of race, creed, sexual orientation, or gender, that she would gladly create custom graphics and websites for clients of any sexual orientation, that she will not produce content that contradicts biblical truth as she views it, regardless of who orders it, that she sincerely believes that marriage is only a union between one man and one woman, that her website design services are expressive and that they are original and customized, that they express her views as well as the views of the couple, that she customizes and tailors the websites through close collaboration with individual customers. All of that was agreed to by Colorado, and may well have been all true. But in any event, it was not an issue that was fought in the lower courts. No one challenged these facts that she put forth. And so it made it, in my view, a pretty hard case for Colorado, as it turned out to be. The court said, the court did not analyze this as a religious freedom case. They analyzed it simply as a free speech case, so that whether Ms. Smith was Christian or whether Ms. Smith was just a person who had these views, whether some future person in the website design business or some other business says, I won't make websites for Nazis, I won't make websites, well, I shouldn't say Nazis, I won't make websites with Nazi symbols on them, I won't make websites with Ku Klux Klan symbols on them, I won't make websites of a variety of kinds that I don't approve of, they would have a similar First Amendment kind of a claim. And the government said, for example, that if Colorado won in this case, that the government could require an unwilling Muslim movie director to make a film with a Zionist message, or an atheist muralist to accept a commission celebrating evangelical zeal, as long as they would make films or murals for other members of the public with different messages. Equally, the government could force a male website designer married to another man to design websites for an organization that advocates against same-sex marriage. The dissent gave a bunch of examples trying to show how awful this was that I thought just disregarded Colorado's stipulations. They said, a photographer who takes high school photographs for the yearbook would be able to claim the same kind of protection. Or I don't know if Sears Roebuck doesn't even exist anymore, but it used to be you could go to Sears and have your family portrait taken in their in their studio, that they would be able to assert this same kind of thing and say, well, we don't like interracial couples, and so we're not going to take pictures of interracial families. And I think the answer is no, because those are not customized productions that derive from, as Ms. Smith does, close collaboration with individual couples and involve original expressive content. You go to get your high school graduation picture taken, look left, click, look right, click, thank you, next. It's hardly the same. I think it's pretty clear from the opinion that I never got a wedding website. I got married before we all had wedding websites, but I assume that wedding websites are largely a cut and paste operation. You find a template that you like, and that company says, okay, here's where you put the picture, here's where you put the directions to the wedding site, here's where you put the list of suggested hotels, here's where you put your paragraph about how you met or whatever it is, and you plug in your content into their template. That kind of thing would not be protected. Now, is that really what Ms. Smith is going to do? Who knows? But she doesn't. She claims that is not what she does. And we didn't have my wife and I didn't have a wedding website, but we did have a custom-made ketubah, and maybe that's a good parallel. We heard through word of mouth about someone who was supposed to be very good. We had a long conversation with this person who asked us about ourselves, about our history together, about what was meaningful to us, both religiously and not religiously, and then designed a completely custom piece of art to be our ketubah. You can get a ketubah, I'm sure, off a website, but that's not what we did. And I would think that if the person who designed our ketubah said, I don't believe in interfaith marriages, I'm not a rabbi who's officiating at one, but I'm designing a ketubah, you're asking for a ketubah for an interfaith marriage, I'm not going to do it, she would be protected by this decision against the claim that she was discriminating against interfaith couples. So I think it was right. And I should make clear that's not what the ACLU thinks. And I'm taking a lot of time on this case, but let me spend another moment on it, which is the dissent also made much of the fact that this was a profit-making business. And they pointed out that earlier cases on which the court was relying involved nonprofits. There was a case involving the annual St. Patrick's Day parade in Boston, where a gay Irish group wanted to march and claimed sexual orientation discrimination when they were told they couldn't. And they lost on First Amendment grounds. The Supreme Court said you don't have a right to march in somebody else's parade with a message that the parade organizer disagrees with. The St. Patrick's Parade organizers were some nonprofit organization. But non-discrimination laws can apply to nonprofit as well as for-profit. In fact, in that St. Patrick's Day parade case, the Massachusetts Supreme Court had ruled in favor of the gay group and said that the Massachusetts civil rights law required that they be allowed to participate in the parade. So profit versus nonprofit status didn't matter there. It was not anything the court relied on in its decision. And so I'm not sure why the dissent made so much about it here. And similarly, the dissent made a lot about the distinction between a business that's open to the general public, that has a storefront, has an advertisement, come one, come all, and people who don't, who operate in a, maybe by just word of mouth or in a different way. The dissent says the law does not require Steven Spielberg or Banksy. I had to look up who Banksy is, and now I forget, but he's an artist of some sort. The law does not require Steven Spielberg or Banksy to make films or art for anyone who asks. Well, that's certainly true, but again, that's true as the law is written, but we're talking about the Constitution here, and if the DC Council or some state legislature decided to apply non-discrimination laws to people who don't open up their doors to the general public, I don't see why the Constitution would necessarily prohibit that. If you're an architect and you're just starting out and you're not yet so good that people are going to come to you by word of mouth, and so you advertise in the local real estate journals, I'm not sure why that becomes a trigger for discrimination laws applying or not.
We need to ask you to put yourself on mute.
I'm just going to go ahead. So I've spent a lot of time on that, and I will move along to cases that don't have anything particular to do with religion. Major case, of course, that you've all read about was Students for Fair Admissions against Harvard University, President and Fellows of Harvard College, 6-3 decision, 237 pages of opinions for those of you who are looking for something to do at the beach. It's interesting reading. All these cases are interesting reading, and even for those who are not lawyers, I recommend that you try one or two of them. They're easily available on the website, and some stuff is technical, but I think mostly understandable, and they write pretty well. And I guess the what I just want to mention about that case is the real clash between Justice Thomas and Justice Ketanji Brown Jackson, our newest justice, who's been there now less than a year. She wrote a solo dissent that really staked out a very strong position about the need for race preference. Here's a quote from her dissent. She says, "Given the lengthy history of state-sponsored race-based preferences in America, in other words, against Black people, to say that anyone is now victimized if a college considers whether that legacy of discrimination has unequally advantaged its applicants fails to acknowledge the well-documented intergenerational transmission of inequality that still plagues our citizenry." So she is out there with language that would support the strongest kind of affirmative action I think that anybody would advocate, would certainly support reparations, for example. One of the things that was quite notable about this term in general was how she did not wait. Justices often wait a year or two after they get on the bench. They're relatively quiet during oral argument. They are relatively, they may join dissents, but they're not out there writing a lot of dissents often. She had, there are people who actually count words in Supreme Court arguments. It's software, I'm sure, that does it. But she had more words than any other justice this term. She wrote, I think, 3 solo dissents. And so she had no hesitation of jumping right in and making herself heard. I think there's been I plan to talk more towards the end about everything that's been written in the last few months about Supreme Court ethics and conflicts of interest and all that. But one thing about this case that struck me that way is that she had been on the Harvard Board of Overseers until she was confirmed to the Supreme Court. She then resigned, and she was recused properly from participating in the Harvard case. The Harvard case and so this case involved 2 universities, Harvard and University of North Carolina. The court had granted cert in both, presumably because there might be a difference between the rules for a state institution and a private institution. But the cases had been consolidated when they were granted. They were going to be argued together, and presumably there'd be a single opinion. Once she was confirmed to the Supreme Court, the court unconsolidated the cases so that she could participate in the North Carolina case, even though she was recused from the Harvard case. And that's not a terribly unusual kind of thing. There are situations where a justice is recused from one case. Maybe his family owns some stock in one company, or who knows what reason. But there's a case raising the same issue that he's not recused from, he or she. And so typically the justice, you'll get a decision by all 9 in one case, and then whatever rule that announces gets applied to the other case. And maybe there'll be opinions about whether there are facts that make it the same or different. But one justice is on the case that's the big deal, and not on the case that's the follow along. But in this case, without making any announcement about it along the way, the cases got reconsolidated. They came out as a single opinion. Her dissent has the Harvard caption at the top, the same as all the others do. It has a footnote that says only participated in North Carolina, but that's a sham. I mean, I really think that's a sham. They were obviously exchanging drafts of this one opinion for months. She responds directly to what's in the majority opinion in the Harvard case. They respond to what's in her dissent. Justice Thomas, in particular, writes, has a long passage in his concurring opinion naming her and taking issue with her view of racism in America. She was in it all the way. And the fact that in her dissenting opinion, she doesn't mention any specific facts about Harvard, seems to me was, good as far as it went, but meaningless. And so with all the attention that's been given to some freebies that Justice that Justice Alito and Justice Thomas have taken, it seemed to me this is at least equally a question to be raised, is how does this person who was on the Harvard Board of Overseers until a year ago participating in this case while pretending to be recused? It wouldn't have made a difference in the vote. It would have been 6-2 instead of 6-3. But neither did Justice Alito's vote make any difference in the case that everyone is so upset about, where he accepted a free flight to Alaska from a guy whose hedge fund was involved in a case, I think, 7 years later.
Or can I just ask a quick question? Did they separately argue the cases before it was decided? Were they separately argued?
They were argued one after the other, but separately, yes. And so she left the bench for the argument in the Harvard case.
Seems kind of weird that they wouldn't have just done what you said they do in other cases.
Right. Roberts wrote the majority opinion. And it was the court's decision. I'm sure it was not Justice Jackson's decision to put them back together. It was the majority of the court that decided to do that. I can only guess about why. My guess is that they wanted to write their major opinion about the Harvard facts, because the Harvard facts were better for their purposes than the North Carolina facts. The records in each of these cases were enormous, and I don't have any familiarity with them, but just by reading the majority opinion, they mostly talk about the Harvard facts, and I'm assuming that's because they were able to point to facts that they liked that were stronger for their purposes coming from Harvard than coming from North Carolina. Moore against Harper. This is a case, you've probably heard the phrase, the independent state legislature theory. The Constitution has 2 clauses in which it talks specifically about state legislatures. The first one is that the times, places, and manner for holding elections for senators and representatives shall be prescribed in each state by the legislature thereof, but Congress may at any time by law make or alter such regulation. The other one is each state shall appoint in such manner as the legislature thereof may direct a number of electors. And so the drafters of the US Constitution gave the state legislatures the job of deciding when elections for federal officials, and mostly elections for federal and local officials are held together, but they don't have to be. But they gave state legislatures the task of deciding when federal elections in their state would be held, where the polling places would be, what times they would be open. Things they didn't even think about 250 years ago, but would you have mail-in ballots? Would you have early voting? Would you have drop boxes for ballots? And what would be the district lines deciding who is in which district? And similarly, who gets appointed to be presidential electors, members of the Electoral College? They could be elected at large for the whole state, as most are. There are, if you remember the red and blue maps from last election day, there are a couple of states where the electors are actually apportioned by congressional district. So you could have a state that splits its electors, one Republican and one Democrat. That's something the state legislature decides. In theory, the state legislature could decide that the legislature itself will select the electors and that the election will only be advisory. And in fact, going back in history, there was a time when state legislatures did that. So the independent state legislature theory says when Congress said the legislature, it meant the legislature, period. And how that has come up in this case in particular was the North Carolina legislature gerrymandered the state's congressional districts. This was a Republican-dominated legislature. The people who didn't like that, people who thought it was an unconstitutional gerrymander, challenged it under state law, and it went to the state Supreme Court. And the state Supreme Court, which was Democratic dominated, struck it down. And the losers said, wait, you can't do that. The Constitution gave this job to us only. You don't have any part in it. And so your action violates our constitutional rights as a state legislature. And they took that to the Supreme Court. Now, there were two cases this year where the court really reached out to decide the case in a way that it didn't have to and maybe shouldn't have. And this is the first one. After that decision, after cert was granted, the state Supreme Court changed colors. It became Republican dominated. The legislature figured, well, now maybe we can win. Maybe we're going to lose in the U.S. Supreme Court. Maybe we can win in our new Republican state Supreme Court. And so they asked the state Supreme Court to reconsider the case, which it agreed to do, and it reversed. And said, no, this gerrymander is perfectly kosher. And then the legislature went back up to the Supreme Court and said, well, now this case is moot. There's no longer any argument here. The state Supreme Court is on the same side as the state legislature. And the bulk of the dissent in this case, so the court decided it was not moot, went on to decide the merits, and decided that an action by a state legislature under these two constitutional clauses is subject to the usual state judicial review by the state court system. And I'll talk about that a little more in a minute. But the main part of the dissent, 2/3 of the dissent, something like that, was on mootness, that this case had gone away. There was nothing to decide. The state Supreme Court's decision that you're reviewing is no longer the state Supreme Court's decision. It's been overruled. I think they had a pretty strong point. I mean, the majority had reasons for what it decided to do, but it would have been totally easy for the majority to say, yes, it's gone away. We'll wait for the next case that's bringing up this issue. They didn't do that. And I suspect the reason they didn't do that is because they wanted to settle this issue before the 2024 election. Who knows what's going to happen? Who knows? For everybody's sake, who knows what's going to happen? We probably won't have COVID. Let's hope. But there's going to be fighting in so many states about moving polling places, whether to have early voting and how much, whether to have drop boxes and how many, even aside from gerrymandering. And there's even the possibility that some state legislature could decide after the election that it doesn't like the results, and so it's going to decide to appoint the electors it wants regardless of whether the other party got more votes in the state. And under this theory, they could do that. Now, Congress, as I read to you, with respect, not with respect to electors, but with respect to all the other stuff, Congress may at any time by law make or alter such regulation. So Congress could set a standard national rule for all this stuff. Congress did eventually set a standard national rule for Election Day. That's why Election Day is the same first Tuesday after the first Monday in every state. The states can't change that. Congress could say early voting is going to be starting such a date. Congress could say there has to be drop boxes, at least one per county or something. But Congress hasn't done that, and in the current situation is not likely to do that. And so I think the Supreme Court just wanted to settle this before the next election, which I think was probably a pretty good idea. But the dissent, of course, was not happy with how it came out, and for that reason was jumping up and down on it was not legitimate to take this case at all because there is no case. In support of the majority's decision on the merits, they had, I thought they had by far the better of the case. Going back more than 100 years, there was a case from Ohio, and then in 1932 there was a case from Minnesota, and then much more recently, in 2015, there was a case from Arizona, and in all those cases, the Supreme Court had, in the first two, they had unanimously, and in the third case, by a divided court, upheld state Supreme Court involvement in these kinds of decisions. So it wasn't like this had never been thought about before. The Arizona case was a split decision, but quite recent, and that the voters of Arizona, where they have a citizen initiative process for putting constitutional amendments on the ballot, had by initiative created an independent redistricting commission to try to get gerrymandering abolished in Arizona. And the legislature challenged that, saying, no, that's our job. You can't take, the US Constitution gives us that job. The voters of Arizona can't take it away. And the Supreme Court rejected that argument and said, if Arizona allows the voters to amend its constitution, then that's kosher. So I thought the majority got it right on that case. The other case in which the court really reached out to decide an issue over a strong argument that it didn't have jurisdiction to decide it was the student loan forgiveness case, Biden against Nebraska. The jurisdictional problem in that case was standing, and standing and mootness are really two sides of the same coin. If there's no real case at the beginning, then the plaintiff doesn't have standing, or if the plaintiff is the wrong person to bring the case. If there was a good case at the beginning, but it becomes moot, then it's the same consequence. There's no longer a valid case, and the court is supposed to dismiss it. So in the student loan case, the question was standing. A number of states, I think 6 states, brought this lawsuit challenging Biden's loan forgiveness plan. And the argument was the states weren't harmed by this. And the states had no standing to raise the argument because they weren't being injured. The state of Nebraska, the name of the case is Biden against Nebraska, but it's Missouri that turned out to have standing. Missouri said that it had standing on behalf of something called the Missouri Higher Education Loan Authority, MOHELA, which was a corporation established by the government, a government entity, but separately incorporated, sort of like Amtrak is a government entity, and like the post office also now is a government entity, but separately incorporated. It can sue and be sued. It can conduct business affairs. MOHELA administered student loans in Missouri, and it got a fee for doing that administrative work. And if the bulk of the student loans disappeared, it would no longer be earning money administering those loans, administering the repayment process, sending out notices when people were late, suing people if they didn't pay, whatever it did. Apparently, it made something like $40 million a year off this administration. and said, we're going to lose $40 million a year if this program goes through. So we are injured. But the question was, they didn't sue. They didn't want to sue. They have an independent board of directors. And Missouri sued and said, we have standing because they have standing. They're a Missouri government entity. And the dissenters there, it was the conservatives dissenting in the independent state legislature case. Here it was the liberals dissenting. Liberals said, no, Missouri doesn't have standing. Mohella would have standing if it sued, but it didn't sue. Missouri is in the same boat as Texas and the other states that sued, which don't have standing. The court easily could have agreed with that. And in fact, I'm told by people who know more about this than I do that this is going to throw a real monkey wrench into many states have these student loan administrative corporation type things, which are constantly suing and being sued. Well, all of a sudden, if this is viewed as an arm of the state, the 11th Amendment comes into play, which says you can't sue the state in federal court. And so a lot of lawsuits that have been viewed as quite normal may all of a sudden be in trouble. But in any event, the court reached out over the dissent's protest to decide the case on the merits. And again, my suspicion is they wanted, this feeling sort of was this needs to be settled now. Otherwise, it's going to have happened. And it's not going to be possible to unwind it years from now and say, whoops, all of a sudden, everybody who thought their loans were gone, your loans are back now. So they reached out to do it and decided that the statute, which is something called the HEROES Act, the Higher Education Relief Opportunities for Students, which was passed in 2003, and which gives the Secretary of Education flexibility in administering student loan programs. And the words that it allows the Secretary to waive or modify student loans. And the statute also provides that the Secretary may issue waivers or modifications only, quote, as may be necessary to ensure that, quote, affected individuals are not placed in a worse position financially in relation to financial assistance because of their status as affected individuals. And so part of the argument was this large-scale forgiveness that wasn't focused at all on individual circumstances, except I think didn't apply to people making more than $125,000 a year, was not complying with that statutory language. But the majority said, we're not actually relying on that. What we're relying on is that the phrase waive or modify doesn't mean abolish, basically. And they go into a number of ordinary life kind of examples. One that caught my attention in the majority opinion said, if the parents are leaving for the weekend and give the babysitter a credit card and say, make sure the kids have a good time, what the babysitter should understand is that she can take them to the pizza place, she can take them to the local amusement park. It doesn't mean you can buy 3 first-class tickets to Las Vegas for the weekend. No one would think it means that, unless there's been a course of conduct in the past where you would know that's what is understood. And what the Secretary of Education is doing here, said the majority, is taking that credit card and buying first-class tickets to Las Vegas, or maybe I should have said Disney World. Same thing, right? Same thing, right? And the dissent essentially said, you conservative guys, you're always talking about judicial restraint, how when Congress legislates, we have to follow what Congress says. You're textualists and words mean what they say. Waive means waive. And what don't you get about waive means waive? So that was That was the argument in a nutshell, I think. And there's been a lot of angst, at least on MSNBC, about this major questions theory that the court said when an action by the executive branch would have an enormous impact on the economy or something like that. When it presents that kind of major question, we're going to expect Congress to be much more clear that it's giving the executive that authority. An analogy that's been used a metaphor that's been used in other cases is that Congress doesn't hide elephants in mouse holes. If Congress is going to give the executive an elephant's worth of power, it's going to say so. It's not going to put a mouse hole in its legislature. And that's an interesting argument, whether the court is just making up this doctrine out of whole cloth and is using it as a way to essentially overrule the legislature. And that's what Justice Kagan's dissent mostly said. You guys are supposed to be so respectful of the legislature. Here you're just disregarding what they said. But to be fair to the majority, they were very clear that although they did talk about the major questions doctrine and it was support for their decision, it was the second of two reasons for their decision. And the first, independently of the major questions doctrine, was that they just said, reading the statute as best we can to figure out what it actually means, we think it doesn't actually mean that the secretary can just waive $40 billion or whatever it is of more than that, hundreds of billions maybe of student loans. When the statute talks about people affected by an emergency and that they should be saved from being put in a worse position. Obviously, lots of college graduates were not put in a worse position because of COVID. All the college graduates who work at my office never missed a day of work, never missed a paycheck. They're all eager to have their student debts gone, but they were not financially, well, at least as far as employment goes, they were not financially harmed by COVID. So another interesting and difficult case. I've got time to try to race through a few more, which I'll try to do. A case I mentioned last year here that might have been very important, which turned out not to be because it left the law unchanged, was National Pork Producers Council against Ross, involving something called the Dormant Commerce Clause. So the Constitution says Congress can regulate interstate commerce, commerce with foreign nations, and commerce with Indian tribes. And Congress does regulate commerce all the time. But starting in about 1880, the Supreme Court decided that some things are so much a part of the national economy that states shouldn't be allowed to regulate them in ways that would harm the national economy or that would harm other states. And this has come to be known as the dormant, the sleeping Commerce Clause. Congress can come in and regulate any time, but until it does, Supreme Court's going to say there are some things states can't do. And mostly what that means is they can't engage in protectionism. They can't say, well, people who produce popcorn in our state can sell it without paying sales tax, but if the popcorn is imported from another state, you're going to have to pay sales tax on that. That's just a hypothetical example, but that kind of protectionism, that's the kind of stuff that the Supreme Court has struck down under the Dormant Commerce Clause. So in this case, California, which produces very little pork, but which consumes about 15% of all the pork eaten in the United States, the voters of California decided that they didn't like the way pigs are raised in most of the United States. They're confined in these little cages most of their lives. They can't turn around. California thinks it's inhumane. And they said, all pork sold in California must be raised in more humane conditions. Cages have to be so big, they have to have so much fresh air, whatever. The pork producers said, you are trying to regulate the whole national pork economy. Pork doesn't go from the farm to California. Pork goes into a big meat grinder, and there's no way to track which sow produced your bacon. And so every pork producer in the country, unless they're a tiny little thing that only sells locally, is going to have to conform to California standards. That violates the Dormant Commerce Clause. And if they had won, I think it would have had an enormous impact on the ability of states to make regulations for their own people. And California is a good example. Before the federal government started regulating auto emissions and seatbelts and various other things about cars, California was often in the lead, saying, we're going to require this for cars sold in California. Well, General Motors is not going to make a different line of cars for California and everybody else, or probably not. And so they were able to pull the whole country along. On the other hand, there certainly could be things that states could do that might be troublesome. Justice Kavanaugh suggested some. He concurred in the decision, but he said, maybe there are some things that wouldn't come out the same way. What if a state law prohibits the sale of fruit picked by non-citizens who are unlawfully in the country? What if they prohibit the sale of goods produced by workers paid less than $20 per hour? Or the sale of goods from producers that don't pay for employees' birth control or abortions, or that do pay for employees' birth control or abortions. So you could have states trying to control the conduct of other states in those kinds of ways by saying, if it's Kentucky, maybe nobody cares, but if it's California or New York, maybe everybody has to worry about it. One that occurred to me is GMOs, genetically modified food, a controversial subject. If a few big states say no GMO food can be sold in our state, does that really put the kibosh on growing it in industrial agriculture? So we will see where this goes, but for the moment, California's law is okay. Pork producers can sell to California or not sell to California, and if the market for pork in California, if the supply of pork in California dwindles to nothing, maybe California will decide that it can't get its way and has to change the law, but we shall see. Well, what else have I got here? Tyler against Hennepin County, Minnesota, a case a unanimous case, and hard to see why anyone would disagree. Ms. Tyler, who was an old woman in her 90s, maybe that's not old to all of my audience, I apologize, had fallen behind on her tax payments on her condo. Eventually, the county seized the condo and sold it at auction for unpaid taxes, and they got back their unpaid taxes, but the condo sold for $25,000 extra beyond the unpaid taxes. And under the county's law, which is common around the country, the county kept the extra $25,000. They didn't give it back to Ms. Tyler. The Supreme Court said 9-0. You can't do that. That violates the takings clause of the Constitution, which says the government can't take private property for public use without paying just compensation. The county was entitled to its taxes, and it was entitled to, the administrative costs of filing the lawsuit and whatever. But once it repaid it, once it made itself whole, the rest of the value belonged to Ms. Tyler. And so state laws in many states are going to fall, as well they should. A case that's maybe of more interest to lawyers, but maybe more general, was Mallory against Norfolk Southern Railway. Mr. Mallory worked for the Norfolk Southern Railway. He alleged that he was injured by asbestos that he had to work with, and he was in the shop when he had to strip pipes and stuff like that. And he said the asbestos exposure eventually injured him. So he sued Norfolk Southern Railway for damages. He sued them in Pennsylvania. Norfolk Southern is headquartered, I think, in Virginia. And he had worked for them in Virginia and in Ohio, but not in Pennsylvania. And Norfolk said, and why did he sue them in Pennsylvania? Pennsylvania has a reputation of being more plaintiff friendly in this kind of a case. And Norfolk Southern said, you can't sue us in Pennsylvania. You can sue a corporation in two places, where it's incorporated and where its headquarters is, which may sometimes be the same place, but may not. I mean, many corporations, for example, are incorporated in Delaware, wherever their headquarters might be. But the law had seemed to be pretty clear that that's where you can sue. Those are the two places where you can sue a corporation, regardless of what your claim is or where it arose. There's another kind of jurisdiction called specific jurisdiction. If you're riding on Norfolk Southern Railway, assuming they had a passenger car, and you were riding on it and you got injured as the train was going through Montana, no question you could sue them in Montana, where the thing happened. If you had a contract that required them to deliver you something in Ohio and they failed to deliver it in Ohio, you could sue them in Ohio. But this is general jurisdiction. You can sue them for any claim, regardless of where it arose or where you were. And Norfolk Southern said no. And I think rather surprisingly, a 5-4 decision by Justice Gorsuch, Supreme Court said, yes, you can. That you can sue a person, and a real individual, a human person, anywhere you can serve him with the summons. And we've all sort of seen this maybe in the movies. Somebody is walking down the street and a processor says, wham, you've been served. You take a vacation in Las Vegas, you can be sued in Las Vegas if they catch you there and serve you with the summons when you're in Las Vegas. And Justice Gorsuch basically said, if it's fair for people, why shouldn't it be fair for a corporation? And why not? But Four said, this is a revolution. It's been clear for many decades, and I think most lawyers thought it was clear for many decades, that a corporation can only be found in the two places where its headquarters or where it's incorporated, aside from, as I said, specific jurisdiction where you can sue them where something actually happened. So that has changed. Pennsylvania, as of a few weeks ago, was apparently the only state that had a statute that said, and why could you sue Norfolk Southern in Pennsylvania? Because Pennsylvania had a law that said if you do business in Pennsylvania, you can be sued in Pennsylvania. Apparently the only state that had that. But I imagine 49 states are going to be pretty quick to say, yeah, you want to do business in our state, you have to appoint an agent for service of process in our state. So that may make life more convenient for lots of lawyers who want to file lawsuits where they live. All right. Should I stop? And yes, I'm going to stop and leave 10 minutes or so for Q&A. If there aren't any, then I'll keep talking, but feel free.
So Art, I actually wanted to raise a question about a case where cert was granted, and I don't know whether the ACLU will stay out of this because it involves the Second Amendment. And this is a case in which the Fifth Circuit upheld a district court decision holding that federal law making it a crime to possess a handgun if you're or a weapon if you are subject to a protective order for spousal abuse or like protective orders was unconstitutional and violated the Second Amendment. So do you think the ACLU would weigh in on this, and do you want to have a view generally about the effect of the Bruin case on gun regulation?
Yeah, so Bruin was last year's Second Amendment case in which the court said you have to look to history of gun regulation in the United States at the time the Second Amendment was adopted and or at the time that the post-civil rights amendments were adopted, which applied the Bill of Rights to the states. And if you can't find an analogy of regulation at one of those times, then you can't regulate in that way today. And here's a good example. The case is United States against Rahimi, where Mr. Rahimi is subject to a domestic violence restraining order and was found with a bunch of guns in his house. And as Harvey said, federal crime. Domestic violence was not a thing. I mean, it was a thing. It was not viewed as a bad thing, or at least not viewed as an illegal thing. I think it was viewed as a private matter. Although I suppose if you killed your wife or injured her seriously, maybe that was a different situation. But in any event, there was apparently no gun regulation involving people with domestic violence. And maybe there was no such thing as a domestic violence restraining order. I think those are 20th century creations. So we will see. I do expect, for a long time, the ACLU did not get involved in Second Amendment cases. I suspect that the ACLU probably will file or join an amicus brief in this case on the side of the federal government. We're not often filing briefs on the side of the federal government because they can usually represent themselves pretty well. But I think our women's rights project, the project that was founded long ago by Ruth Bader Ginsburg, would throw a fit if we weren't going to file a brief here on the government side, and I suspect we will.
So we're going to open up the questions. We'll take a couple questions from people here, and then we'll take it from the chat box. So
thanks, Art, very much for the presentation. I have a quick comment and a question. The comment is just in talking about the Goff case, and you were mentioning the DC legislation. So I just wanted to mention, folks here, that for many years while I was at the American Jewish Committee, I was heading up a coalition that would have amended Title VII to provide a better definition for undue hardship. And I'm happy to say that at least if we didn't get the law passed, we kept it on the table long enough, that issue on the table long enough for it now to become a case that went to the Supreme Court, where they've now defined undue hardship as substantial expense, I think is the term. And it's really good news for religiously observant people in terms of their ability to be accommodated. And I will mention also that there's a webinar that I'm going to be moderating on this decision for the ABA on July 18th. And if people want more information, please be in touch with the sponsors of this program, and they can put you together with me. The question I have has to do with 303 case. Given that Colorado sort of gave away the store in its stipulations, to what extent are these issues still susceptible? Let's say you have a real litigation where the parties are challenging an idea that you're dealing with creative activity. To what extent are those issues still open? Whether in the context of website design or florists or photographers or anything else, for an argument to be made that the proprietor is on the wrong side. I mean, at some point, something clearly there's got to be protection for creative right. exercise. But to what extent are the doors of the court still open for a legitimate discussion as to where that line is to be drawn, so that there is or is not First Amendment protected activity?
Yeah, is everyone on the Zoom able to hear the question? Was there a mic that picked it up?
Yeah, I think it was heard.
Okay, good. So I think the answer is yes. I think the courthouse doors are totally open to that kind of thing. If you're selling cookie cutter website templates, I think you're going to come out the other way. I think the wedding florist is going to come out the other way. I'm not sure. I mean, sure, a floral arrangement is expressive to some degree, but what does it express? I mean, the bride and groom may have very strong feelings. They want red and white carnations and not pink. But that sounds like a hard case to me for the florist. On the other hand, I think the wedding photographer probably comes out the same way as 303 creative. I mean, wedding photographer really has to sort of be in the mix at the party. And I don't think a wedding photographer, frankly, could do a very good job if the whole time the photographer was feeling like, I'm sick to my stomach being here. And I would hope that the bride and groom would feel the same way. That, we don't want to, unless you're out to make a legal point, we don't want a photographer who can't join in our celebration to the extent that you sort of have to do a good job. But I think there undoubtedly will be plenty of follow-up cases where the lines won't be nearly as clear, in part because the side that's trying to enforce the civil rights law is not going to agree to that kind of stipulation.
Vicky, do we have any questions online in the chat box?
Yes. So the question in the chat box is from Nancy Ween. She says, if the issue of the right to boycott as is protected form of free speech under the First Amendment were to come up before the Supreme Court, where would you stand? She knows that the ACLU has supported the right to boycott in numerous cases, which have arisen. Is this another instance in which you would disagree with the ACLU? And if so, how do you justify your view? Why should boycotts of Israeli settlements be carved out as exceptions to the right to boycott?
That's an excellent question. I'm going to give a fairly short answer. I have a court hearing at 2:30. I need to get home and put on a suit and tie and turn on my Zoom. So I'm not going to stay too much longer here. The ACLU actually had a case involving BDS that tried to go to the Supreme Court this term. We represented a publication called the Texas Monthly. The publisher of the Texas Monthly refused to sign a contract. I mean, the Texas Monthly got a certain amount of advertising from some state agency. And as a condition of getting that advertising, signing a contract with the state agency to accept its advertising, the Texas Monthly had to sign a contract with the agency. And one of the required clauses was, I don't boycott Israel or companies doing business with Israel. The publisher refused to sign it. Texas said, well, then we can't advertise with you. And the publisher sued, represented by the ACLU. Lost in the, I think it was 8th Circuit, but not on constitutional grounds. The 8th Circuit, there was a fight about exactly what the contract clause was regulating or what it required. And the 8th Circuit said all it's regulating is commercial activity. It's not requiring you to express an opinion about anything. It's sort of similar to contract clauses that prohibit discrimination. You can think whatever you want about whether same-sex couples are good or bad, holy or sinful. All you have to do is agree you're not going to discriminate against them in your business if you want a contract with the government. And the 8th Circuit said that's what's going on here. It's not imposing on your First Amendment beliefs or your expression, and so you lose to the publisher. So the ACLU asked the Supreme Court to take up that case. Cert was denied. The ACLU said this is a First Amendment violation, and cert was denied. I imagine the ACLU and other groups will continue to be looking for cases to challenge these kinds of requirements. I think it's a complicated issue. I do think it depends a fair amount on the particulars of what it is that someone's being asked to do. And sure, I've got a First Amendment right not to buy grapes if I don't want to, but I don't have a First Amendment right not to do business with a same-sex couple if I'm selling flowers. And so what's the line between a protected consumer boycott and an unlawful refusal to do business? There's certainly a lot of government regulation in the labor relations field about unlawful refusals to do business. Secondary boycotts are not allowed under the National Labor Relations Act. You can strike the company with which you have a labor dispute, but you can't picket some other company down the street in order to put more pressure on the company that you're striking. Or I'm not doing a good job of explaining why you would do that, but unions have sometimes done it or wanted to do it, and the labor law doesn't allow it. And that's not been viewed as a First Amendment violation. It's been viewed as a regulation of labor management relations. So I don't have a firm view on the question. And so I'm gonna cut off my answer.
I'm going to honor Art's time commitment. We have no program in August. We'll be back again in the fall, and we'll announce our next program. I want to thank everybody, both online and in person, for attending, and thanks, Art, for another great presentation.